Procurement Act 2023 Knowledge Drop Series for Contracting Authorities. Changes to Assessment and Award. Part 4 of 6. In Part 4 of this Knowledge Drop series, we will cover the changes around the Supplier Exclusion regime, how the Debarment List will work, the new requirements prior to awarding a contract, the new publishing requirements following the award of your contract, more robust approach to supplier exclusion. The Procurement Act aims to better protect contracting authorities from suppliers who pose a risk to effective competition for public contracts, public confidence in procurement, reliable delivery of contracts, the protection of the public, the environment, public funds, national security, and the rights of workers. The Procurement Act introduces new grounds to support contracting authorities to exclude suppliers. Misconduct by other suppliers and by individuals who are connected with a supplier are also now in scope, meaning that suppliers cannot avoid exclusion by bidding in the name of a subsidiary or by dissolving and reforming under a different name. As with the previous regulations, suppliers who meet one of the grounds for exclusion must or may be excluded from a procurement procedure following an assessment of their circumstances by contracting authorities. Suppliers can avoid exclusion by demonstrating satisfactory self-cleaning activity. For example, that they've taken effective remedial action to prevent further misconduct occurring, such as by improving compliance and training procedures. There are exemptions to the exclusions rules where exceptional circumstances apply, such as where there is an overriding public interest in permitting a supplier to compete, or in situations relating to critical defence and national infrastructure matters. Your procurement and commercial teams can assist in navigating the exclusions process. Debarment List. The Procurement Act includes a new provision for a debarment list of suppliers. The debarment list will set out very clearly which suppliers must and which suppliers may be excluded from procurements. A supplier will be added to the list if, following a debarment investigation, it is found that an exclusion ground applies and the supplier has not been able to produce sufficient self-cleaning evidence. The investigation process will be managed in most cases by the Procurement Review Unit, which will be covered in Knowledge Drop 5, to ensure consistency, fairness, and transparency when suppliers are considered for addition to and removal from the debarment list. A new National Security Procurement Unit is also being established to support exclusions and debarments on the grounds of national security. The debarment list will be published and maintained to help contracting authorities navigate the mandatory and discretionary exclusion stage of their procurements, but it does not replace this part of the procurement. A change in award procedures. The feedback given to suppliers can be inconsistent and not always considered to be useful, which may result in complaints and legal challenges that could have been easily avoided. Sometimes, unhelpful feedback is down to a lack of clarity about what is an acceptable standard of information to provide to unsuccessful suppliers. The Procurement Act requires an assessment summary to be provided to each supplier that has had their tender assessed, along with the successful supplier's assessment summary. This should be less burdensome, as you'll be able to provide the assessment summaries you would produce as part of your procurement process, redacted for commercially sensitive information, rather than having to create a new document unique to each tenderer outlining the relative characteristics, advantages, and disadvantages. Although you are not obligated to do so, You may choose to accompany these assessment summaries with supplementary information, akin to debrief or standstill letters. There is a new step requiring a mandatory contract award notice signalling the intent to award a contract to be published after the supplier's assessment summaries are issued. The publication of the contract award notice will start the standstill period, where it is applicable, which has changed from 10 calendar days to 8 working days, and must be observed before entering into a contract with the successful supplier. Once the contract has been entered, a mandatory contract detail notice has to be published within 30 days in most cases. For the majority of contracts awarded with a total value of £5 million or more, contracting authorities will also be required to publish copies of their redacted contract documents and details of 3 key performance indicators. Key performance indicators should be those which the contracting authority regards as most material to performance of the core contractual obligations. Recap. You should now understand the changes around the supplier exclusion regime, how the debarment list will work, the new requirements prior to awarding a contract, the new publishing requirements following the award of your contract. In Part 5 of this Knowledge Drop series, we will cover the contract governance requirements under the Act, including contract modifications, performance, and termination. The Act's transparency ambition and notice publication requirements. The role that the Procurement Review Unit will play in improving compliance with the legal regime.
This material has been produced for the purpose of learning and development and does not constitute and should not be relied upon as legal advice. This material is accurate as at October 2023. Fact sheets for the following exemptions can be found on gov.uk. Concessions, light touch, defence and security, Northern Ireland, Wales, schools, utilities. End of animation.